Thank you to the Earth Institute. Thank you to everyone for the opportunity to share today. So I'm going to really give an overview of some of the research that I conducted in the Property and Justice Project, which is an ERC-funded project that's just about to end. And I'll explain, what's different about that project and what it's hoping to contribute to some of these international legal issues, particularly in the context of a triple planetary crisis, climate change, pollution, and biodiversity loss. So as I said, it'll be an overview. Please, if you have any questions afterwards, if I haven't touched on anything, I'd be very happy to discuss. So I'll just pull out some quick points here. So in the law, while we do have protection now for landscape, particularly through UNESCO conventions and certain treaties to do with heritage, broadly speaking, in the law, land is seen as property. And so it's the idea that land can be owned, that it is infinitely extractable, it can be exploited, it can be shared as a bundle of rights, it can be exchanged on the global marketplace. There is no inherent duty of care within property, because part of the definition of ownership means that you can own it and you can do what you want with it. So within the law, the idea of jus habitendi, it means that you can own it and you can destroy it. There is one exception that has been carved out, you may be familiar with, which is that indigenous property, the idea of communal tenure, exists. That's been recognized in different regional legal systems, so through the African courts, but perhaps most familiarly to people would be the Ewas-Tigny judgment before the Inter-American Court that recognizes that indigenous property emerges from a different source, that it's not amenable to just being exploited in this way because of indigenous ontologies and indigenous ideas about land predating this idea of property. And even today within international law, and particularly international environmental law, the environment doesn't really have a definition, even though there's a body of law regulating the environment. So nature or the environment is seen as, again, amenable to property rights. And if there are any issues to do with land or the environment, the state in international law is responsible for addressing any matters to do with land in the public interest. Now, what's interesting from the point of view of the Property and Justice Project is that it wasn't always this way. So this idea of land as property is fairly new. It emerges around 1800, which is only 200 years ago. If you think about human presence on the earth over millennia, this wasn't the way people thought of land as at all. Land was always contextual. Land was always communally managed. And this idea of landscape that we're using is not meant to impose one way of thinking about land, because as you'll see, the term landscape comes from Europe, and of course, the world is not Europe, but landscape is really meant to express this idea of land being shaped by people. And you can see it in the etymology of the word. Land or landschaft or landskap from Germanic languages, the idea of shaping land, the cognate from Latin, pagus or community, land being cultivated. And it's decided that landscape is the land, the relationship people have with land, and that this people-place relation is specific to a particular ecosystem, and it defines that place and the people. So it's been described as a chaotic concept because it represents so many things. It's the material land, it's the people on the land, it's the spiritual, cultural connections with the land, all linked together. And Kenneth Alwig, who is a landscape geographer, is probably the leading exponent of this, because he's the one person in geography who sort of made a link between geography and the law, and saying that landscape is actually legally entangled, like it has a relationship with the law. And landscape used to signify this idea of community justice, a working polity, where people's relations with land, these practices in the land lead to customary law, that these rules regulated the land and led to a certain identity because of people working together. But we lost this idea of landscape, and landscape re-enters the English language in the 15th century, associated with landscape painting, landscape gardening, perhaps the way we think of landscape today, this idea of landscape as a scenic value, a vista, a view. And so there's a shift from what I've been speaking about here, this idea of a working polity where representative qualities signify political representation, to solely visual representation in the 15th century. So why do we see this shift? It's mainly because of this introduction of property. It's mainly because property is introduced during empire. And we see this extended from the enclosure of the commons in England. And we see these practices all over the world as a result of the British Empire, which is the largest land-based empire of the Western European empires. And it changes the way, because of the law, it changes the way we think of the land, because the law provides a way of thinking of land that becomes authoritative, that becomes objective, and is passed down and is seen as, you know, the relevant way of thinking about land. So as a result of enclosing land and creating property rights, we have this idea of nature, as I said, that is amenable to property rights as a result. So many of the disciplines that we think of today, the ecological sciences, botany, ecology, and so on, are developed to protect plantation agriculture, to protect colonial agriculture in the Caribbean, in India, parts of the Western Cape, in Africa. And that's why we see this idea of nature being aligned with property. And then this idea of landscape destruction is preserved in property, this idea that property can be divided up and exchanged without considering the way in which communities relate to land and their specific rules that have been developed to maintain those ecosystems. These place-specific ideas about land, these place-specific rules are lost in favor of this generic concept of property that can be exchanged anywhere in the world. So we have all these different places being brought into the empire, from the African continent to Australia to India, Latin America, everywhere. All these different ideas about land, they all become subject to property, and we collapse all these diverse, disparate places into the empire as property. And so this is where, so the monograph that I produced for the project, Placing Property, is essentially this. It's talking about this landscape property divide and why this is the basis for much of the environmental crises we see today. So as a result of maintaining the split between landscape and property, by reducing landscape to property, land becomes capable of limitless extraction. We don't pay attention to material limits, and we don't pay attention to the ways in which nature is lived in. And this is really what landscape offers, in thinking about land as more than property and thinking about land as a people place. Hopefully we can begin to think about reversing many of these problems that we have, because even though everybody's experiencing climate change, biodiversity loss, pollution, they manifest in place-specific ways. So for example, what the African continent will be experiencing won't be the same as what's going on in small island states, and the small island states in the Caribbean aren't experiencing vulnerabilities the way in which islands in the Pacific are. So the idea of vulnerability as geographical, and that these vulnerabilities aren't being considered when you're only looking at land as property, as completely exchangeable on the marketplace. So yeah, so how can we think about reimagining land and reclaiming some of these ideas? It's this idea of landscape as this relationship between land, law, and people, and how we restore this in the law. If land is cultural nature, if it's a basis for cultural identity, customary land practices, and a sustainable way of life, then it can't solely be defined by ownership. And an important point is that landscape is not against ownership. So when you had different ways of thinking about land, you also had ownership. But the point was that ownership was one interest in land, and it didn't trump all of these other interests the way we have today, an idea of land as only ownership. So the idea of different interests in land, including ownership, meant that these different interests not necessarily in harmony, but they could be in tension. They could be in tension with each other, and one could prevail, for whatever reason. But the fact is these different interests existed, and they could push against each other. And when land uses are contested, it also means that that's democratic, as opposed to having an imposed way of thinking about land. So just some, potential features of what I'm talking about when I say landscape, as what it means to be a community of law. That, again, these places are not interchangeable. An island ecosystem isn't like another island ecosystem necessarily, that these collective practices are very much place-based, and they give rise to certain laws, rights, and institutions. As a result, they inform the cultural identity of the place. They're dynamic. They can change. And the point of a landscape is that it's adaptable and its rules are adaptable to natural phenomena. And they're also flexible. They continue to exist for a very long time, even when property, as I said, was imposed in 1800. Landscapes, living landscapes, functioned alongside these imposed rules for a very long time. So because we have this global system based on property, we have this way of thinking about the world, the globe, that is this abstract construct, and it's led to, other related concepts. So other related legal concepts to do with race, to do with nature, to do with capital, and all of these nodes have developed the system that we have today. So the idea of thinking about landscape and calling attention to landscape is really to do away with this idea of the abstract globe, and to do away with the idea of international laws based on this abstract globe, and to rethink rethink how locally defined landscapes can be relevant to understanding these problems. I suppose what I wanted to do with the research is to highlight the fact that property was not inevitable, that property is not the result of, an organic evolutionary process that people arrived to. It wasn't democratic, it was imposed. And it arose in unsustainable circumstances, to do with colonialism, genocide, slavery. And so communities all over the world are trying to challenge this idea, this dominance of property. And they're doing this in one of two ways. They're either trying to protect their existing systems, so indigenous communities can do this through human rights law, or you have other communities that are trying to challenge land use decisions, often in planning, to say that they are unsustainable or unfair, and they don't pay attention to these sustainable people-place relations. So I'd just like to draw your attention to a recent case before the Privy Council, which is an international court. It is the final court of appeal, so that's the Supreme Court for certain countries that are former British colonies. So it's binding in a number of different places, and because it's an international court, it's persuasive to other international courts. What's interesting about this case is that this case had to do with the island of Barbuda, and this community is Afro-descendant. So one of the things we've tried to do in the project is to, while we fully understand and respect the idea of indigenous communities and their relationship with the land, one of the things we've been trying to push for is to say that this isn't only indigenous, that there are other communities in the world that have embedded relations with land that are very often not recognized. And you have Creole communities, Afro-descendant communities, peasant communities, other ways of defining themselves, even recent immigrant communities who have or believe in place attachment. And these communities may be relevant to thinking about sustainable ideas in the environment. And they should be given at least some attention, rather than giving, multinational companies or investors the benefit of the doubt when they're developing land. Like, people who are attached to the land should be, given some consideration. And this was the context. So these people here, John Mussington and Jacqueline Frank, he's an ecologist, she's a school teacher. They applied for judicial review, meaning they wanted, this is the idea of challenging land use decisions by the government. So they challenged the planning authority in their country, and saying that this permission, they granted permission to build an airstrip to support exclusive villa development, luxury villa development on the island. And, John's an ecologist, and John and Jacqueline felt, this is, which would destroy the way of life on Barbuda. And very interestingly, the central government, in their defense, questioned whether John and Jackie had any right to bring a case because John and Jackie don't own property on Barbuda. And so generally the convention is if you bring a case, you have to demonstrate substantial interest. You have to show that you personally are affected. One way you do that is to demonstrate that your property has been affected. But they didn't actually own any land in the area where the airstrip had been built. Now, the basis of their argument is that they have a long-standing relationship with the land. They're descendants of enslaved Africans. They've been on the land for 300 years. They developed a way of relating to the land that kept them alive and kept the ecosystem functioning and working. But this is actually not a legal argument because this isn't recognized in the law. And what's interesting from what I'm calling this spatial justice perspective, the protection of landscapes, is that Barbuda is part of the state of Antigua and Barbuda. So it's a unitary state. That's the name of the state. But they're two very different islands and they're two very different places. So even though they have a similar history of slavery and colonialism, Antigua, the larger island, which has like 90,000 people, is a typical former slave colony. It was extensively managed for plantation agriculture. Its soils were exhausted. It's today a major tourism destination. Barbuda, although was settled during the same period, could not support plantation agriculture. It's very prone to drought. It has a very thin soil cover. So the islanders there ranched and did small-scale farming, and they actually fed other islands that were slave colonies as a result. They were not managed by the crown. They were leased to one family, one particular family that owned the island from the 1600s all the way up to the 1900s. And so because they didn't have that turnover of being an intensively farmed plantation economy, they were pretty much left to their own devices. They developed a strong kinship. They weren't always bringing in new enslaved Africans to provide labor. So they have a different way of being with the land. They have a different identity separate from Antiguans, even though they were brought together as an independent state in 1981. So the point I'm making with the spatially just perspective is that if you only look at this in terms of the common law and the legal implications, of course, the central government, which is based on Antigua, the larger island, is responsible for making decisions about the land in Antigua. But if you go down to the material level, if you go down to the level of the landscapes, you see a very different picture in terms of how people feel about the land, whose values are considered, if this is democratic at all. And as I said, the argument that they had, which is that we have been on the land for 300 years, we are attached to this land, we care for this land, it's important to our human rights, isn't a legally recognized argument. They could not make this argument in court. So instead, they had to contest the planning authority's decision and simply say, we don't think this was done properly, that your planning decision. So this is just a picture of the airstrip that was built. So this land here is actually pre-Columbian forest. It's one of the few ecosystems in the Caribbean that, wasn't destroyed during colonialism, and it now has this strip driven through it. They also were concerned about the wetlands in the area. This is a protected Ramsar site. It's protected because of it's an intact system, and it's important for particular bird species, and there's a lot of subsistence farming and hunting in the area. So the judgment is significant. It's significant because it doesn't recognize a right to landscape, and it doesn't use language like landscape or spatial justice. But what the court did say is that property is not the only basis for making a claim. And the court recognized that John's expertise in ecology, he's worked on environmental impact assessments, he's lived in the area, he's a citizen. They both demonstrate that they, have such care for the area. It's a critically endangered ecosystem. All of these factors should matter, and people should be able to bring cases and contest government decisions where they believe they would affect the community. And so this is, this opens the door to thinking beyond property in environmental cases and cases to do with environmental justice. So, as I said, spatial justice offers another way to think about the law beyond property. The law itself can be spatially unjust. You can have what appears to be nominally, like formally a legally correct decision. So the issue here isn't that the government cannot, give permission for land use decisions, and the central government certainly did that. But if you consider the impact on the landscape, you see a different picture altogether, right? As I said, it's also thinking about, while you respect the idea of indigeneity, thinking also sort of crossing the indigenous divide and thinking about other communities that have long-term relationships with land. This is something you're also seeing in Brazil and other parts of South America, for instance. Other places, other communities that have relationships with land that should also be considered. And while, currently in research, we're thinking about issues to do with racial justice, economic justice, climate and environmental justice. What do these things look like in a particular place? And how can that drive more precision in terms of crafting policies and laws that pay attention to what goes on in a particular place? Because as I said, what's a climate just policy or solution for Mozambique is not going to be the same for Jamaica or, Samoa. So what does it look like in a particular place? And hopefully I haven't gone over, but in closing, really, it's the idea that landscapes are underutilized as a tool for environmental justice because of the centrality of property law. And we need to sort of recalibrate that relationship within the law to begin thinking again about the relationship between land, people, and the law. So we're sensitive to the limits of local landscapes. That's it. Thank you.